Hello, I'm Ben Choder, President of the Digital Communications Division at West. Thank you for joining us today. As May 25th approached, the light and heat around GDPR compliance seemed endless, fueled by concerns of lagging behind and facing huge penalties and fines. As we each navigated our own GDPR journey, we learned more about our data and our businesses than we expected. In many ways, we were ready for the challenge, and in others, perhaps not quite as ready as we thought. Well, May 25th has come and gone, and what have we learned? What can we take away from this journey? Today, we have assembled a prestigious panel of experts to tell us what they learned from these preparations, both good and bad, and what GDPR compliance has revealed in new opportunities to be more effective and more strategic in our communications. So thank you for joining today, and enjoy the webcast.
Thank you, Ben, and welcome everyone to our webinar, What GDPR Has Taught Us and What's Left to Learn, brought to you by West Digital Communications. I have the great pleasure of being your moderator today. My name is Nicole Couture. I'm the Commercial Director for EMEA and APAC here at West Digital. Before I introduce you to the fantastic panel joining me here today, I have a couple of housekeeping items to go through with you. First, we definitely want to hear from you throughout the webinar. Please feel free to key in your questions in the Q&A module that you'll find on the webcast player. We'll get to your questions a little bit later in our presentation. We're also streaming our presentation today live via Periscope, so please feel free to follow us on Twitter at WestCorpDC. And if you're tweeting about today's event, please use the hashtag WestGDPR. Before you leave the presentation today, please don't forget to spin through the download section of our webcast player where we've stashed a number of helpful resources for you. And if you want to share today's presentation, you'll find the share button in the bottom right-hand corner of your webcast player. So with me for our discussion today is a fantastic collection of privacy, compliance, and product experts, and I'm excited to introduce you to them. Let's start with Amanda Chandler, the Global Privacy Manager at Vodafone. Amanda, can you tell us a little bit about yourself and your role at Vodafone?
Sure, Nicole. So I sit in the small but perfectly formed privacy team at Vodafone Group. There's 4 of us, depending on how many contractors we have in at any one time. And we have a number of roles to play. First of all, we are the group privacy and data protection function that delivers compliance for the group companies. But we also have a role mentoring, coaching, facilitating our community of privacy officers and privacy councils across the Vodafone world. And they deliver compliance locally.
Great. Thank you, Amanda. We're so glad you could join us. Also joining us from Euroland IR is their Director of Product Strategy, Akshay Kappa. Akshay, why don't you tell us a little bit about the work you do at Euroland?
Thank you, Nicole. Hi, everyone. My name is Akshay Kappa. I head the Products and Strategy team at Euroland. Euroland helps stock-listed companies all over the world, providing them with stock charts, best practice investor relations solutions, regulatory news, and a host of subscription services. That's the topic of our discussion today.
Great.
And just one more point, we have worked with amazing partners like West, and also we have a direct sales channel.
Fantastic, and we love working with Euroland. So glad you could join us. Also with us today is Natalie Farmer, an associate at Cleary Gottlieb. Natalie, welcome. Please tell us a little bit about the work you do.
Thanks very much, Nicole. I'm an associate at Cleary Gottlieb, as you've said. We handle a number of data privacy and data protection compliance projects for our clients. We have a global footprint, which means that we advise clients on a number of extra territorial applications of regulations such as the GDPR, which I'll be happy to talk to you a little bit about today. We also help clients navigate data protection rules in the transactional context, as well as delivering compliance solutions to them.
Fantastic. Thank you for joining us, Natalie. And also with us, of course, is our Regional Privacy Counsel at West Corporation, Stephen Taylor. Stephen, we'd love to hear more about the work you do at West.
Well, thank you very much, Nicole, and thanks everyone for putting this panel together today. I think this is a great opportunity to talk about GDPR and some of the processes we've all put together and worked on. I'm a privacy counsel at West. I helped manage our global GDPR compliance program. West, as you all probably know, is a communication technology business. We process a lot of data. Be happy to talk a little bit about how we've put together a compliance program and answer any questions.
Great. Thank you, Stephen, and thanks to all four of you for joining us today. So to kick off, before we talk a little bit about your own journeys and how your companies approached it, the first thing I want to talk about is the applicability of GDPR outside the EU. So we're sitting here in London today in our office, and this is certainly a going concern for all of us in Europe and the UK. But one of the most common questions I get from my teams in the Americas and Asia is, why the heck should I care? So I wonder if you can give us a little sense, or for how GDPR applies outside the EU and why companies in Asia Pac or the Americas should be thinking about this. Maybe Stephen, if you want to kick us off.
Absolutely. Happy to talk about that, Nicole. GDPR applies to personal data of data subjects based here in the EU. However, wherever that data is processed, whether it be in the EU, in the US, in Asia, there are rules that apply to businesses outside of the EU. So it has an extraterritorial approach. A lot of companies have offices in Europe and around the world, meaning this regulation is something that is a reality and something that we all have to comply with.
Mm-hmm. And I think applicability is probably something you deal with a lot, Natalie, in your practice.
Absolutely, an awful lot. So we've got, clients, and as a firm ourselves, we're based in a number of jurisdictions, both inside and outside of the EU. Our clients very much situated in the same way, and it's a real shift from under the directive, where we really concentrated on the location of the processing, to now the new reality being needing to concentrate on the location of the data subject.
Yeah.
And there are some, consequences of that weren't immediately foreseen by clients, and many organizations, despite their global footprint, if you are processing or controlling data outside of the jurisdiction, the jurisdiction of the EU, you may well be caught, and your processors, also situated outside of the EU, may well be caught, and it's not always obvious that that would be the case. So a lot of analysis, I think, is going on and continuing to go on to make sure that those who are caught are aware then that's addressed and that full compliance is achieved for them all.
I'm thinking of global footprints. I can't think of a bigger global footprint than Vodafone. This has got to be, applicability has got to be a hot topic for you guys, Amanda.
Well, I think the way that we look at it is in two ways. So first of all, yes, we're a global company. Global communications is extremely complicated. Trying to work out what processing is happening inside or outside of Europe becomes somewhat challenging when you've got data flowing around networks, just because it goes into Europe and out again, does the law apply? So we've approached it in a slightly different way from a policy point of view. When people interact with their mobile devices, it's an incredibly private and personal experience. People are on their phone, it's with them 24/7. And we don't believe that the world is split into privacy haves and privacy have-nots simply because you're born in a jurisdiction that does or doesn't have data protection or privacy laws. So we've chosen to apply the privacy standard based on GDPR, but flexing for non-European markets where appropriate across the Vodafone world. So that's our first approach. The second approach is we are increasingly seeing non-European jurisdictions introducing GDPR-like legislation. So if we want to be ahead of the curve in those markets, we might as well adopt the best practice from our GDPR program outside of Europe as well as inside.
Right, that makes a lot of sense. I'm sure it's something you guys see at Euroland as well, actually, right? Because you have clients all over the place.
Yes, it started in 2014. In fact, the law in Korea started in 2011.
Wow.
The Privacy Information Protection Act, PIPA, that meant that clients were taking the data or controlling the data, as we would say in the future. It's like they need to process the data properly according to the legislation, as my co-panelists have said today. But if you are a product person or a processor outside the EU and want to make business here in the EU, you definitely need to have data retention policies. How do you do this? Exact, clear principles in place, and that's absolutely important from outside the EU as well.
Great, that makes a lot of sense. So we'd really like to hear mainly about your GDPR journey so far. So I'd love if we could go down the row and if you could tell us a little bit about your organization and how you shaped your approach to GDPR, and if you can touch on maybe the difference or any differences that it might make if you were a controller or a processor. Amanda, why don't you kick us off?
So when we look at Vodafone as a set of global companies, each of our local markets is a highly regulated entity in its own right. So therefore, it makes it stronger that, for the argument's sake, that they are controllers in Spain or in UK, rather than being able to look at the Vodafone Group PLC turnover for that big fine. So part of our programme was to ensure that whilst we could still define the local markets as controllers in their own right, we had a consistent but universal standard towards delivering the processes, delivering the tools, delivering governance and assurance. And the reason that we did it that way is, as I say, not only we wanted to make sure that the local markets or the network operating companies remain controllers in their own right, but we wanted a consistent approach so that we couldn't have regulators play each other off against each other. Because if we set a higher standard in one market in Europe and someone else in Europe chose to do a lower standard, or what might be perceived to be a lower standard, the regulators talk to each other. Let's be sensible and open about that. So we needed to maintain a consistent standard. So what we did is we had a centralised steering committee group. We did the design for what each of the data protection by default process should look like, and then that was rolled out individually in each local market in a standardised way, and they reported on their progress against those deliverables.
That's great. Such an organised approach. That's amazing. What about you, actually? What was the preparation and the lead up like, and was it any different in terms of how you approached it because you guys are a processor?
Yeah, some part of our services, subscription related services for investors, that's where GDPR applies. So we started in Feb 2017. We started speaking to our proactive clients, like Amanda's, the controllers, and then we went on, they gave us a lot of feedback, really prepared, well planned. And then we went on to Natalie's, like legal counsel, and then we got their ears. And then we started looking at the contractual parts and preparing them, processing. We had to handhold somebody, and then we had to actually negotiate on DPA agreements with somebody. So this is how it went. And May 25th has went and gone now. So we are in a happy place right now.
We all got there in the end, right? Nobody died, everything went okay.
Exactly.
25th came, it was a big day, and then it was okay, right? What about you, Natalie? What was the process like for you guys?
We took the exact same approach for the firm as we did with all our clients, which was a very, I think, structured approach to gathering stakeholders, trying to get an agreement across those stakeholders of how the compliance project should look. Spending time sitting down with stakeholders, introducing them to concepts and interviewing them about exactly what they did with data within the organisation. And that was quite eye-opening. Because I think that we didn't even realise, and many clients didn't realise, how many stakeholders we really needed to pull in to get the full holistic view of what was going on in the entire firm, in all the locations globally. So not just the obvious legal, compliance, IT, but also HR, procurement, business development, communications. And at that point, working with auditors and consultants to really map the data, and that's when the lawyers can really then start doing the lawyering and drafting policies, drafting procedures, making sure that they plug any of the perceived gaps in that gap analysis. And that's the approach that we've rolled out for clients time and time again. And at that point, really crafting something quite bespoke for each business that works and that is continually workable, so that they can achieve compliance by May 25 and then ongoing compliance going forward.
It must instill some confidence in your clients, though, that you deployed the same sort of process, the same thinking around your own compliance as you recommend to them.
I think so, and I think that it's important that we did that ourselves as a firm by ourselves so that we can feel their pain. So we know how difficult it is sometimes to pin down exactly what is going on, what processes are there, what processes need refining. We have our own war stories.
For sure, for sure. What about you, Stephen? What was the lead up like at West?
It was a lot of work. As my panelists have said, it often started a year or two before the 25th of May. Certainly the lead up, the 6 months before the 25th of May, there were a lot of long nights, a lot of conference calls with different team members from around the world putting together a program that that would ensure we met GDPR compliance. We took it kind of an approach in two different silos. Firstly, as a data controller and how we handle our employee data. And we've got a lot of employees in Europe, and we have a lot of data about them, and it's stored in a lot of different locations. So we had to put together a team built of members from legal like myself, including HR, IT, and really going through the core compliance processes of GDPR and making sure we met those processes. And then the second silo was as a data processor. We process our customers' data as a data processor. They're our data controller. So there were some differences. In particular, as a data controller, you need to get the lawful grounds for processing. As a processor, it's really you need the instructions from the controller. So we had to take that kind of angle. And it was a lot of work, and it included participants and team members within West from just about every continent we operate. Every team, every business unit was pretty much touched on in some capacity. Some of our business units process more data in Europe than others, so we probably put a greater emphasis on those business units. But it was a lot of work, and it continues to be a lot of work, Nicole. It's a project that I think will be with us for some time.
Yeah, it's not going anywhere, is it? An absolutely ton of work. So all of that work, all of that effort and planning, and now that it's here, what are some things that you do differently than you did before that sort of stick out as big changes in terms of how you do business? Yeah,
I'm happy to answer that one. I say firstly, our vendors. And the new relationship we now have with sub-processors. As we all know, if you are a vendor and as a multinational company, you will have vendors. Often you'll have support for a lot of different areas. If your vendor processes your customer's personal data, for example, that will create a relationship under GDPR. I think under Article 28, there's a whole bunch of rules and regulations around what terms and conditions have to be passed on to your sub-processors. You have to make sure that you've got terms and conditions from your controller passed on to your sub-processors, so there's a lot of back-to-back agreements going on, and that's tough because sometimes you'll have agreements that differ a little bit with terms and conditions. What does that mean practically? It means we have to think twice now about whether we can hire a vendor to do certain tasks, because it means we're going to have to pass on a whole bunch of terms and conditions. It means that a lot of our customers are going to have to agree whether they want that vendor as a sub-processor. So that's really had an impact as a practical example. But there's been probably several examples I could give you. But that is certainly one that is a big one for us.
Yeah, and that must be huge for you guys as well, Natalie, in terms of contracting, right?
Absolutely. We're finding that we're supporting our clients much more in a type of contracting that we probably wouldn't have done previously in the procurement side, as you say, helping to liaise with vendors to negotiate those terms, which have been scrutinised really, really heavily because of the size of fines under GDPR. Liability and risk allocation is huge, and there have been some, lengthy negotiations of clauses of those Article 28 data processing contracts that I wouldn't have even foreseen being necessarily big ticket items. So everything from audit rights to breach notification, timelines and procedures, of course, then also liability management. Yeah. And we've been far more involved in that, both for ourselves as a firm and also to help our clients navigate that more and more, and I think we'll continue to do so. And
what about you, Akshay? From a product perspective, are there things that you guys do differently now in light of GDPR?
Yeah, I would say, apart from what Stephen touched upon, I would say a couple of things. One is internal processes and client communications. That has changed. When we started doing this, different teams had access to data. Now, certain specific people have access to data. And what else I could say is that client communication, encrypted emails, the sender and the receiver both know the importance of what's being sent. And that kind of changes is something that, apart from what Stephen said, I would point out.
That's a pretty positive change, I think, isn't it, too, though, right? To have that level of visibility and understanding, both on sender and receiver side, is actually, I think, a positive outcome. What about you, Amanda? What does Vodafone do differently today than it did before?
Well, I think there's two things. So first of all, internally, through our compliance program, we've moved privacy and legal risk management away from the legal teams and out into the business. They are now sort of first-line defence. And the reason for that is that, from our perspective, privacy or GDPR risk is generated or caused by the way the business does its business or the way the business wants to do its business. So we've pushed the accountability for decision-making, and that can be a double-edged sword, which we may touch on later, back out into the business. So they are primarily responsible now for deciding on the consequences of their own action. Contracts are great, but they only work when something's gone horribly wrong. We'd rather stop something going horribly wrong first. So that's sort of the biggest change that we've seen internally, along with breaking down silos. I think Stephen touched on a good point earlier when he was talking about his programme, just how wide your stakeholder group is for GDPR. You know, if you're doing something like Sarbanes-Oxley looking at a finance function, it's one function, it's a handful of controls. GDPR touched on nearly every part of our business, even those parts like property, you know, managing leases, those types of things. Okay, small amount of personal data, but it still needs to be managed. So that's the first thing that I would say. The second thing that I would say, particularly in the controller-processor relationship, is certainly now within our supply chain management, I'm seeing a lot of our vendors or suppliers re-establishing or renegotiating their position as to whether they truly are a processor or whether they're a controller in their own right and therefore are more responsible wholly for the legal risk that they are responsible for generating, for determining. And that's quite an interesting point of view, because I think previously this sort of black and white picture of who's controllers, who's processor, it just fell down as it did. You know, everyone, oh, I'm supplying you a service, I must be a processor, I'll sign your DPA. No, this is all getting slightly tougher now, it's more nuanced, and people are, certainly our vendors are trying to carve out their own scope and responsibility as controllers.
And I do want to talk next about the differences between processors and controllers and how we navigate those two sort of designations. But first, I want to know, and I'll just throw this out to the group, were there any gotchas, like any surprises, something good or bad that came out of your implementation of GDPR that really threw you or that you did not expect?
Yeah, I can say something that comes to my mind immediately. When we started very early, we sent the same set of questions to 2 different local entities who were regulating the GDPR in their respective countries. And we received completely different answers from them. And that's one thing. I mean, this was very early, but still that was one thing that was really surprising.
Yeah. That's some, we would assume, kind of black and white sort of legislation could be interpreted in 2 completely different ways.
Yeah.
I think for me, the sheer volume of information that people had, the amount of information that they were gathering, sometimes for reasons that didn't immediately seem clear or were unknown to anybody. So the sheer volume of data gathering that was going on was quite surprising.
Yeah.
I think just the exercise of uncovering how much data, especially at a large multinational like West, how much data exists, and just finding out, oh my goodness, we have this server and it has all this data and no one's ever said anything before. We got to get
where is this
a process in place to make sure that we've got retention guidelines and that the security is up to speed. But I mean, thankfully there wasn't too much of that. But I think a lot of businesses, if they're candid and open, will say that yeah, we've encountered situations where we just, you know, it's like lifting up a rock and a whole bunch of surprises are underneath. And I think that has been a challenge. And then trying to immediately fix that problem and make sure that we have a process in place before the 25th of May. You know, it's a bit of a quick process sometimes, but that was certainly a challenge for us. Yeah.
What about you, Amanda? Any surprises?
So I think the pleasant surprise that we had was that there was an awful lot of good practice and process out in the organisation. We're a very matrix organisation. So a lot of, like the group technology, they had a lot of really good, robust processes that we could actually just plug GDPR checkpoints into. So that was the pleasant surprise. And similarly across HR, you know, it's very well organised from a process documentation point of view. How do you onboard someone? How do you go about resourcing? So there was quite a nice being able just to plug in those privacy checkpoints. So that was the good surprise. The sort of the bad surprise, if that's actually a phrase, but you know, was that lots of things happened within Vodafone that, because we're all Vodafone, you know, the transfer of data from a local market to a Vodafone shared service centre sort of went on at a business level, and it all worked quite nicely, but it wasn't really documented within our intercompany data processing arrangements because, you know, Dave in UK HR just wanted to outsource this process to a team in India. You know, it went through finance, someone signed the form, numbers got allocated, process happened. again, so Vodafone works very smoothly, but trying to sort of identify those intercompany exchanges and making sure they come within our intercompany data processing agreements to clarify that processor-controller relationship. We thought we were all over it, but then we found it was just much more amorphous and nebulous than it wasn't documented.
Much bigger than we all thought. I would say
absolutely.
that was my gotcha or my surprise, is that I literally just could not believe the volume of email in the week before May 25th. I don't think I've ever gotten so many emails in my entire life. Maybe combined. So one of the core concepts in GDPR is this concept of a controller and a processor, right? Essentially, who actually owns the data versus a party which might be just processing it on behalf of the controller. So I want to dig in a little bit into those differences between controllers and processors. So first, for our controllers on the panel, which I believe are Amanda and Natalie, yes. What's the relationship like with your processors? How did you manage the process to identify those processors? And what's the one thing you would recommend to processors in order to better work or enable them to work more easily with their controllers?
Well, I think we went through quite a long process of looking at all the vendors that we had, trying to establish what we thought that they were doing, analysing them and just determining whether they were controllers with respect to us or just our processors. And that ended up often being a dialogue because some processors had very different ideas of what it meant to do what they did. And it's been working with them closely to make that analysis and come to an understanding. We've in some cases been very proactive, gone out with terms. In other cases, processors and vendors have been proactive and come to us, and that's been almost 2 year long process of trying to bring all of those agreements up to date. In terms of what I think it would be helpful from my perspective on the controller side for processors to know, I think, like I mentioned earlier, we've found that we've negotiated parts of those arrangements that we might not have anticipated that we would. So breach notification deadlines and audit rights and things like that, I think sometimes they're misunderstood and they're not as scary as they need to be.
Right.
The GDPR tells us that our arrangements with our processors need to have audit rights built in, but that is auditing for the purpose of ensuring that everyone's complying with the terms. It is not big audits of entire organisations. Nobody wants to do that.
Right.
I don't think any controller really wants to do that either. It's just being able to make sure that everyone's complying with the things that they need to be complying with. The same with breach notification. These deadlines are not meant to scare anybody. It's just that if there's a breach, we need to know. At the same time, we, as a controller, aren't aware until we're told about the breach, so we don't necessarily have to panic if we don't find about it in 24 hours or 48 hours even. I think there has to be some pragmatic solution to both of those clauses.
Yeah.
They do have to be in the contract. So,
Of course.
but we found that most of this is quite collaborative, and you're two parties trying to work towards what will work for them both. So.
Right. And what about for you? I know Vodafone is both controller and processor, but in your role as controller.
So we're very fortunate. We have a centralised supply chain management function. So we have pre-selected suppliers. I think there's about 2,000 on our list, and they are in category codes. So the first thing we did was to look at the category codes and say, well, if you're a supplier in this category, you are more likely than not to be a processor. So we were able to separate out our supply vendors, our suppliers in that way. That was step number one. And step number two was we tried to identify where we had existing data processing agreements. Okay, they may be under the old regime, but a data processing agreement is better than no data processing agreement. So that narrowed down the list even further, and so we were able to concentrate in the first wave on those processors or suppliers who were processing personal data where we needed to negotiate a GDPR-ready data processing agreement. And then we'll work our way back through the list to the ones that have an old data processing agreement, and then the sort of long tail, as it is. So that's how we manage the process of identifying our suppliers. We then did the thing that everyone does, is just wing out your standard data processing agreement to whoever's email address you've got for the supplier, in the vain hope that they hand it to a legal person and it will go through. So that was a bit of a challenge. But as I say, what we have found is that a number of our suppliers have come back to us and said, well, actually, we think in this circumstance, what we're providing to you, we're actually a controller. And as I say, I'm happy to have that discussion. So what I think would be really useful, and what I appreciate from my suppliers or processors, vendors, whatever you want to call them, is if they are pre-armed with a diagrammatic, albeit high level, sort of schema of what product or service they'd have for Vodafone. You know, even if it's just a PowerPoint with boxes here and says this box is in India and the data goes from your data center in Germany over here, and these are the teams that access it. Brilliant. Just give me a high level picture and we can all start speaking from the same point of view.
Yeah.
And then at the same time, if they have a legal pre-analysis of where they think they're a controller and where they're a processor, then we can have that discussion and we can start in a more meaningful place rather than them just rejecting our data processing agreement out of hand.
Yeah, so coming to the table with a little more information
Yes,
to be ready
exactly.
to have that discussion. And so same question now for the processors, right? What was, the engagement with your controllers like leading up to May 25th? What's that engagement like now? And what's the one thing you would recommend to controllers as they interact with their processors? Actually, why don't you kick us off?
Yes, I would actually borrow a couple of phrases that both of the controllers used here.
It's probably a good idea.
The controllers, when they're prepared, they were guiding us through for all the application level configuration changes that was required, and that was a dream, definitely. But there were certain controllers, because of maybe the lack of personnel or the team size, etc., having, when we had these prepared presentations, they were not willing to have that dialogue that Natalie was saying. And then just pushing, here is the DPA, or here is the liability clause, here is this, here is that. And my one guideline, or not guideline, but suggestion to the controller would be that if a processor is servicing more than 500,000 clients, they're doing it in a certain way and they have configured everything, asking them to change something, and if the processor says, yes, I will do it, then they are not doing it right. They're just saying it for the sake of getting this done.
Right.
So have that dialogue and look at that presentation. That's what I would say.
What about you, Stephen?
Well, I guess I'll make 2 points. One, I think the processor-controller relationship is almost, under GDPR, like going into a partnership to some extent to deal with, all right, if something does kick off, there are these 25 million euro fines, and we're in this together. So I would say working positively and openly and transparently between the two parties is very important, because we're essentially sharing this liability. So that's very important to remember, I think, just as a starting point when entering into discussions with the controller. But I guess practically for us, from a contracting perspective, I mean, that's kind of the challenge. That's really where the heart of the relationship is. Negotiating, as the panelists were talking about, different terms and conditions. We've received many of those kind of bog standard. Here's our template DPA. Please sign it. We have our own template as well. We have our own processes at West, so we typically try to respond by saying, well, here are some of the ways we will process your data. We may process it outside of the EU, for example. And that can be a challenge with some of our customers who want the data to stay in the EU. So I guess a recommendation I would make to controllers would be try to be understanding, and try initially when you're dealing with your data subjects and getting your lawful grounds for processing to not have too narrow of a set of instructions if possible, because often your processors will need to process the data a little bit differently than maybe how you have to process. And obviously we can accommodate to some extent, but to onshore data in one country, for example, can be a major problem, and that can almost be a deal breaker with some of our controllers unless we can come up with a solution. So flexibility and trust are probably the two two points that I would emphasize to controllers.
I think that's a really good point, that flexibility, right? You certainly would want to have a set of sort of parameters in mind, but selling yourself that you're only going to accept data within the EU might mean that you maybe don't work with the best service provider, and that as long as the company, the processor, can show you why and how they might be offshoring that data, if it's to get you a better product or a better solution, to keep an open mind around that.
And it's important to remember GDPR has the mechanisms to allow for lawful transferring of data outside of the EU. There's various ways to do it, and as long as one of those ways, whether it be standard contractual clauses or privacy shield to the US, these are valid grounds for transfers. And we at West try to emphasize those grounds when making our case that your data is going to leave the EU and come to the US, for example, where some of it might be stored and processed, but we will do it in accordance with what the GDPR allows for lawful grounds of transferring.
Right,
so,
right.
Yeah.
Keep an open mind. I like that. So next I'd like to talk a little bit about this idea of making lemons into lemonade, right? I think most businesses see GDPR, or certainly in the lead up to the 25th of May, saw GDPR as just this really onerous set of requirements now imposed upon businesses as it relates to how they process data, right? But I think, now that it's here and the sky didn't fall, right? It came and went and everybody's okay. I'm wondering about the upside. Does GDPR have the potential to save your business money or even to make you money? What about your thoughts? Maybe Akshay, you can kick us off for this one.
Yes, from the product standpoint, yes. Product standpoint, I would say that privacy by design, that's something that helped us get that edge, I would say. We didn't have a heavy legal team in order to do that. We got really good legal consultation, but we had these kind of discussions within the product team. So they were in that kind of discussions from 2017. So that meant our our privacy by design on our product development has already started happening well before the GDPR live date. That I would say is like the lemonade part,
Right.
where it's something positive out of this.
And what about for Vodafone, Amanda? What's been the upside?
So I think there's two upsides, really, and they're both internal. I mean, I don't think compliance with GDPR is not going to be a USP in the telecom space. People don't wake up in the morning going, woohoo, I've got privacy and I'm going to choose Vodafone. So for us, it has been mainly internal, and I think there's two things I would emphasize. One is that by collecting all the knowledge we had about processing around the organisation and consolidating it in a centralised way rather than having pockets of information dotted around has enabled us to be more streamlined and effective and move towards a better data governance and technology infrastructure and architecture point of view over time. So removing duplication, getting rid of unnecessary data in a more effective and efficient way, obviously saving costs. And the other thing that we did, and this was a direct result of the GDPR programme, is we, at Vodafone Group, the privacy team, got global licenses for an online privacy risk management and compliance tool that we have now rolled out across both our European and non-European markets. And that goes back to that point I was making earlier about having a consistent and standardised approach to things like data protection impact assessments. But obviously, by doing it once and paying the licence fees once, we've sort of enabled the local markets to come on the same journey, the network operating companies to come on the same journey with us to do things in the same way that we want us to, but they get it for free. So obviously, we're delivering compliance in a cost-effective way as well. And the third thing I would say is, as part of that journey, we also identified that there are a number of other disciplines, if you like, throughout Vodafone that were approaching the business with questionnaires. There was information security, there's business continuity management, there was privacy. And we were sort of going to the business units with very similar questionnaires, and the business was like, I've already answered these questions for information security. But now we've identified that, and we can use the one centralised privacy tool to narrow down and have one questionnaire for the business which ticks off or asks the relevant questions for the different disciplines. It also means that we're less of a compliance burden on the business functions that we engage with.
I love a good IS questionnaire, me. Good times. What about you, Natalie? What's been the upside?
I think for data protection lawyers generally, it's the feeling that it's much higher on the agenda. So it's making its way to the agenda at board level. It's becoming something our clients really, really care about, and it's as we spoke about earlier, a lot of these principles are identical to the ones that we had under the directive, but now all of a sudden they're being given a lot of airtime. So I think there's a certain satisfaction, frankly, in the fact that that's happening, because these are really important principles for all customers of all businesses, and now I think much more resource and time is being dedicated to addressing what were always principles that we cared about.
I guess we all feel a little safer using the internet, maybe. What about you, Stephen? Has there been any upside for you?
Yeah, I mean, I agree with what Natalie was saying. I think that GDPR has helped to really just clarify and create an orderly framework now around processing data. We often say that the activity of processing data these days is a regulated activity, and GDPR certainly has the fines to back that up, and you get people's attention when you tell them, look, this is a serious piece of legislation. The fines are up to 25 million euros. So you get the attention and the engagement really of businesses, of consumers. And also, I think GDPR helps to protect consumers' rights a little bit better. I think we now have certain minimum expectations of how our data will be processed in this digital era that we live in. Data these days is often in a digital form, which makes it maybe a little harder for a consumer to know where it's being processed or what's being done with it. And GDPR helps to just give those kinds of rules and regulations a practical way of following and implementing. But it's a major piece of legislation, and I think that the benefits in the long term will be it helps your company get its data in order. It helps you plan around what you can and can't do with data, and I think that's probably not a bad thing, because if it's too unregulated or if it's too unclear, that could create a little bit of misconception in the marketplace.
Yeah. I think there may have been a brief window in the lead up to the 25th where this could have been a competitive advantage if you were further ahead than maybe your competitors. Do you guys see this going forward as something that has the potential to create competitive advantage, or is it really just a level setting in terms of the playing field and how all providers deal with the data that they collect? What do you think?
I can start, yeah.
I think certainly if you're a service provider and you have a strong GDPR compliance program and you can communicate it effectively to a controller versus another service provider who can't, given that window we're currently in, I do think you can have a competitive advantage in the market. Although in a few years from now, when everyone is really supposed to be fully compliant and have a GDPR compliance program in place, will there be this level of discrepancy? I don't know, but absolutely, if you can demonstrate your commitment to data protection and if you're processing data as an end in of itself, as a business, I think that will help you.
What do you think, Akshay?
Exactly. We have started bringing our data protection into our sales discussions, our calls with our customers. The big, high risk clients, they are looking at it and then they're appreciating that fact. Just bringing that to the table is definitely important for other clients to acknowledge. Okay, they're not just ticking the boxes, but they're doing this right.
Right.
Maybe the time frame is something we are going to take a look, but we are definitely using this on our sales calls right now.
I'll bet your sales guys love that. So I think at this point we should hear from our audience. So if you haven't done so already, please use the Q&A module on the webcast player to key in your questions for our panelists today. I've already got a couple that have come in here. So first, this one probably best for Amanda. Do you think the requirements of GDPR are more onerous for controllers or for processors, and why?
I think it's going to depend what type of business you're in. So for Vodafone, we're a controller, particularly for the provision of telco services, fixed or mobile line connectivity. The GDPR is not our only regulation. We've got other regulations to comply with. So when we were talking about, our competitors, for us, GDPR may actually be more onerous than, say, a typical over-the-top player, because we're not just the pipe, we're the content provider. But I think But when we're a processor, and we do actually act as a processor in our enterprise space on behalf of our large global enterprise customers, I think the actual, the lens that you look through is very different. So for a processor, it's much more being able to demonstrate, that you have your robust information security measures in place, that you understand how data flows, where customer data are, which teams around the world are touching on that data, where you have suppliers of maybe software who are providing support and maintenance. So those things are actually a lot more difficult to document because networks and technology is so disparate and interconnected, and actually trying to get a clear picture of that so you can scope out your responsibilities and how you apply. I think that's operationally more difficult, whereas the controllers may have more theoretical legal risk. I think the actual business of some of processors, as I say, where when I have a relationship with a processor, that processor may have a whole network of sub-processors behind, and actually for the processor to get their arms around that environment is operationally and technically more difficult than actually my obligation to get consent for processing.
Right, yeah. I will say, mainly in my businesses, we're processor. It's a little scarier, I think, than being a controller. I think I might prefer to be in control of the data myself. So another question, I think maybe Natalie, you might be able to speak to this one. Have you seen any convictions or fines? Have we seen any convictions or fines actually brought to or against somebody since the 25th of May?
We're still waiting. It sounds a bit strange to say we're waiting for someone to get fined, but it will be helpful in many ways to understand exactly how the regulators are going to treat this new regulation and then brand new enforcement powers. We haven't seen it yet, and we need a barometer. It's really difficult to operate in a vacuum, and we know the fines can be, up to 4% of global turnover, which it sounds incredible, and yeah, exactly. It makes everyone a little bit nervous. So we are waiting to see that. We recently saw the UK regulator issue the maximum fine it could, or issue a statement of intent to issue the maximum fine it could against Facebook for a breach of data protection law under the old regime, under the Data Protection Act 1998. And I think if you assumed that they would have taken the full force of the law under the new regulation, so they fined them £500,000 for their part in the Cambridge Analytica scandal, they could have, I think, fined them somewhere up to 1.6 billion, I think, under the new regulation if you use their previous year's global turnover. So it would be good to understand what the intentions are.
It really would be.
But we are waiting.
Because that's a big difference, right? That
Huge.
is significantly larger. And I think everyone is, as you say, sort of just waiting with bated breath to find out just to what extent are the regulators going to leverage these new much bigger fines, and will the first few that we see out of the gate be super big to sort of scare everybody off, or will they be sort of middle of the road to kind of try and drive enforcement?
Other enforcement powers as well, which we haven't seen them quite exercise yet. So it's going to be a really interesting time when we first see them going out of the gate with these.
And that's an important point in that they do have other ways to correct an inaction or a wrong action. It's not just fines. A regulator can work with a company to help get them compliant and give them advice on what would be a good GDPR program, or help fix a problem they have with their systems. It's not just getting fined, but I think we're all waiting to see what is the majority of the recommendations from these regulators going to be. How is it going to vary from country to country as well? Are some regulators going to give bigger fines in the EU than others? We just don't know. It's very interesting times.
But I think as well, from the regulator side, it's going to be very difficult for them to sort of wing out a demand for 4% of annual global turnover, you'd have to have committed a really egregious, intentionally, flouted a concept or a GDPR principle. I mean, I suspect that what they're going to have to do is to wait till they've got a really strong case where they feel that they have the evidence. I mean, we're a large company. I've got a raft of litigation lawyers. We've got a GDPR compliance program to demonstrate our Article 83 defences against that major defence. So I suspect they may want to keep their powder dry until they don't, they are confident that they'll be able to land a fine.
Right, they've got to know that they can really push this one all the way to conviction. Otherwise, that some of the legislation might appear to lose its teeth. Right?
Yeah.
Yeah. That's a really good idea there. So, one of the questions that's come in, I think this one actually you might be interested in. In all of our interactions online today, people end up subscribing to things, collecting subscribers, both from a processor and controller standpoint. What are some of the best practices that you recommend to your controllers who might be collecting subscribers, managing opt-ins? I mean, I know it's something that almost all of us deal with in some way, shape, or form. What are some of those best practices that you talk about with your clients?
Absolutely. We put some of these examples in place, show it to our clients, and ask them to follow this and also improve this from their ideas as well. One of the things is just telling them what they are consenting for, and being very honest about it, and not just saying, I understand everything. And like a follow-up email or an opt-in confirmation email, also carrying the same school of thought, not just putting the front-end form alone, the next point. And then also continuing that logic well within your emails, managing subscription. In fact, people subscribe to a lot of things these days. They don't know if they have a subscription or not. So we put out something called as, do I have a subscription? So that kind of a very open standpoint is something that we recommend clients.
That's really good. Yeah. So one question that's come in, and I think that would be interesting to hear from pretty much everybody about is, let's see if I can phrase this, how do you move from designated privacy or GDPR teams, sort of scrum teams that we all built in the lead up to the 25th, to this just being part of your business? Has that been a challenge for you guys within your organization as we moved past the 25th of May?
Privacy by design, I think, is the answer to that. Ideally, all members of our business units think about privacy when developing new products, when selling products. They can always check with their legal team or their privacy teams if they're not sure if a certain product or doing a certain task could violate a privacy law. But awareness is a big part of it, and one of the ways we try to get awareness is regular training. So we have there's annual tests, we do videos, we have like a privacy awareness month, just constantly reminding employees the importance of privacy.
Yeah. That makes a lot of sense. How at Vodafone, how did you guys move from your perfectly formed privacy team to the new norm?
I think it's a challenge. How do you move from a transformational program into BAU? And I think your Ben on the video earlier made a good point about heat and light around the 25th of May. And there is a real danger that senior management go, well, 25th of May went, no one died, no one got arrested, job here's done, let's move on to the next program. And trying to maintain that constant sort of senior level, top-down, bottom-up focus, I think, is a real challenge. I mean, Steve's right, privacy by design, building that process out, training and awareness is all, all helps. As I say, and as I said earlier, one of our themes or objectives with the GDPR compliance program in Vodafone was to really push accountability and responsibility to business leaders, whether that's a function leader. And therefore, they do have within our risk and assurance governance model a responsibility. We go to them as a function leader, and they have to report on how well they're delivering on an ongoing basis. But I do think that, and it sort of plays into the point that we were talking about with these massive fines, I think there's, at the same time, this sort of compliance program has also, because of this fear of large fines, which is great as a stick to get people to do things, but then it actually, puts the fear of God in them as well. And what we're seeing now is, and it's a favourite saying of mine at the moment apparently, that the four-letter acronym GDPR seems to have sucked the common sense out of otherwise intelligent professionals. And I think one of the key things is much more about how do you rebuild confidence in business people that they so that they can take sensible privacy risk decisions without having to come to the small and, as I say, perfectly formed global privacy team for sign off on absolutely everything.
Right. A big challenge, I'm sure, for most companies out there now that it's here and we've sort of moved on, but really haven't moved away from it, right? So before we wrap, I'm going to ask for one final thought, recommendation, best practice, do, don't, can't, won't, whatever you would like to say to our audience. One last thought from each of you. Stephen, why don't you kick us off?
Well, I think I'll go back to a point I made earlier in that data in today's age, processing data is a regulated activity. It's not something that we can do on the fly anymore. Companies will need to devote at a minimum a team to putting in place processes and policies around managing data and taking it very seriously. It's an age where what we do with data, what we do with information matters, and I would say that take it very seriously and get the right people involved, and then it becomes part of your everyday processes.
Right. What about you, Natalie?
I think building on what Steve said, don't think of the 25th of May as this destination that you arrived at, but it being an ongoing compliance project now. And part of that is going to need to be continuing to document your decision-making process and just keeping the right stakeholders aware that demonstrating compliance with the GDPR is one of the first and foremost requirements of the GDPR. So everything you do internally, continue to document it. Have that paperwork behind you that explains exactly why you do or do not have a DPO or a representative, why you feel comfortable to take certain processes forward and not others, your DPIAs, and just know that it's an ongoing obligation. It's not going away anywhere, even though the 25th of May has passed.
I would say, for the processors listening to us today, I would say that you have started something doing just taking the DPAs, all the boxes in the DPAs, but be responsible, continue, keep going, and also guide the controllers through what you're doing, be transparent. And for the controllers watching today, I would say be flexible and have the dialogue.
Right.
Yeah, that's it.
What about you, Amanda?
I would say for any compliance program is to the greatest extent possible, one, build your privacy checkpoints into existing business processes rather than trying to build a separate privacy compliance bureaucracy. So if you have a supply chain process, there is a due diligence process. Plug your privacy checkpoint into the due dil process. Secondly, and if at all possible, I talked about the digitisation, getting a centralised tool so you can have one methodology for doing DPIAs. They're all recorded in the central tool. So whether it happens in the UK or Lesotho, we have a global picture of decisions made. And the records there, and to Natalie's point, you are able to demonstrate. You may have got the decision wrong, according to the regulator. That's not the problem. As long as you can demonstrate that you had that thought process and it's documented, then you're a long way home.
Right. Like answering hard math questions back in school. It's fine if you get the answer wrong, as long as you show your steps.
Exactly.
You can show how you got there, right? I like that. For those of us not very good at math, right? That's very reassuring. So first, I want to say thank you to each of our panelists today. Stephen, Natalie, Akshay, Amanda, it's been a pleasure to speak with all of you. Thank you so much for sharing your insights with our audience. I also want to thank everyone who's joined on the webcast for their questions and their participation. We hope that you can join us for our next webinar in the series, which is around driving success with owned media. That's happening in September. And we're really hoping that you can join us for our Client Summit happening in New York City in October. So on behalf of all of us here at West Digital Communications, we're so pleased that you could join us today. Thank you so much for your time, and please enjoy the rest of your day.